Okay, hi again. This is Seema Sapra again, and I'm on part 3, my third video on the issue of my whistleblower complaints against General Electric Company. So, in this part, I want to talk about uh, the fraud committed by General Electric Company through its purported lawyers and purported constituted attorney on the Delhi High Court. In the writ petition that I had filed in the Delhi High Court against General Electric Company and its two Indian subsidiaries, which was writ petition civil number 1280 of 2012, 3G companies which were parties to this petition, respondents in this petition, were General Electric Company, GE India Industrial Private Limited, and GE Global Sourcing India Private Limited. This petition was filed by me in February 2012. On 7th of March 2012, the Delhi High Court issued a notice, which is like a summons in a civil case, issued notice to the 3 General Electric companies. Now, I'm going to show you, if I can, the order of the court. I'm not sure if this will work. If I can, the order of the court in this matter is actually available on the website of the Delhi High Court. So the order dated 7th of March 2012, passed by the Delhi High Court in writ petition civil 1280 of 2012, read, coming to the writ petition, paragraph 4, coming to the writ petition, issue notice. For the present, it is deemed appropriate to confine the notice to respondents 1 to 7 and respondent number 12. Now, what was the prayer in this writ petition? The prayer in this writ petition, which was filed by me, was, let me just tell you what the prayer was. Just give me a minute. I'm opening the appropriate file in my computer to read out the prayer in this writ petition to you. Just 1 second, please. Okay. I'm going to, I had in the past, and I probably have them online somewhere, all these documents, but I'm going to upload all these documents again and provide links on these videos that I'm now making. So, yes, so the prayers in the relief sought in writ petition 1280 of 2012 was, summon the records of respondent numbers 2, 4 and 5 on the whistleblower complaints made by the petitioner, and after examining the records and hearing the respondents, issue a writ of mandamus to respondent number 4 directing that respondent number 7 be disqualified and respondent numbers 1, 6 and 7 be blacklisted from the diesel and electric locomotive tenders. Now, respondent number 7 is General Electric Company. Respondent number 1, is General Electric Company. Respondent number 6 was GE India Industrial Private Limited. Respondent number 7 was GE Global Sourcing India Private Limited. So, respondent number 1 in writ petition civil 1280 of 2012 was General Electric Company. Respondent number 6 was GE India Industrial Private Limited. Respondent number 7 was GE Global Sourcing India Private Limited. So the first prayer was that they be disqualified and blacklisted from participating in the diesel and electric locomotive tenders. The second writ was a direction to respondents 2, 4 and 5, directing them to respond to and act upon the said whistleblower complaints in accordance with law. These were the respondents 2, 4 and 5 were the Indian state respondents. Prayer number 3 was direct the respondent number 2 inquire into the commission of criminal offences including forgery, bribery and public corruption arising out of the petitioner's whistleblower complaints, and direct prosecution of GE employees and government officials and public servants found involved and complicit. Prayer number 4. Enforce and protect the right to life of the petitioner and direct that the petitioner be provided full protection and safety and be immediately relocated to a safe house. So this was a petition which was filed by me in the Delhi High Court on 29th of February 2012, on which the Delhi High Court issued notice to respondent number 1, which was General Electric Company, to respondent number 6, which was GE India Industrial Private Limited, and to respondent number 7, which was GE Global Sourcing India Private Limited. Now, this part of my video presentation concerns the fraud that was played on the Delhi High Court in response to this court notice. This was a writ petition seeking disqualification of GE itself and its subsidiaries and their blacklisting from participation in any Indian government tenders for a period of 2 years. This petition and this relief, if granted, had the ability to affect GE shareholder prices, and under public listing rules in the US and the SEC directives in the US, GE would have had to disclose the pendency of this writ petition to its shareholders in its annual reports, in its various forms, reports which it submits to the SEC. And also, GE, after the meaning of a court notice being issued to GE in this matter meant really that GE had to file a reply to this writ petition, and that reply had to be supported by an affidavit, and that affidavit had to be signed and attested by someone who was the duly constituted attorney of GE and authorized by GE to file that affidavit. Now, coming to what happened, GE filed an affidavit in the first place without producing any authority documents. That affidavit was signed and attested by a man named K.R. Radhakrishnan, who claimed to be the company secretary of GE India Industrial Private Limited, and he claimed that he had been appointed as the constituted attorney of General Electric Company and as the constituted attorney of GE India Private Limited, GE India Industrial Private Limited, and GE Global Sourcing India Private Limited for the purposes of this writ petition.